and these are very short.
Not yet. Good afternoon, everyone. Applicant, can you confirm that you are hearing us clearly?
Yes.
Good day again, Chairman. Yes, we are.
Respondent, are you hearing us clearly?
Chairman, yes, we are hearing you clearly.
I'd like to advise the respondent to be visible within the frame of the camera, please. And same for the witness when it's the witness's turn to present. Mr. Balruk, have you received the documentation?
Yes, Chairman. All three witness statements were sent, as well as the skeletal submission was resubmitted from the LSA's part, and they would have also sent a copy of the evaluation of the tender, the evaluation report for the tender.
Okay. Have you had enough time to review the documentation? Do you wish to continue with the proceedings?
Okay. Since the proceedings now go forward with the witness statements, then yes, we don't have any issue with moving forward with that part. But of course, the technical the evaluation report is 261 pages. So I guess at that point we'll see how we move forward with that how you treat with that piece of information.
Okay, permit me a moment, please. Yes. Applicant, Mr. Balruk, I am advised that the document to which you refer was submitted as part of the package on May the 1st. Can you confirm whether or not you have seen that?
Chairman, as per my records, we have never seen that document previously. That is the reason why, even in the case management conference, we would have requested what was the engineer's estimate, because we had no prior sight of that.
Our records indicate that it was indeed provided on May the 1st. It was part of a document called Scanned. Pause briefly, thank you. Thank you. I would like to ask a question of the respondent. Respondent, did you provide that document to the applicant in your response? Did you serve the document?
Chairman, the document was provided this morning.
And the document I'm referring to as was just noted by Mr. Balru is the evaluation report.
Chairman, we were under the impression that that document would have been provided to the applicant through the OPR, because we did submit it to the OPR when we submitted our package.
Respondent, may I ask that you be on screen at this point in time while we address this matter, and when it comes time to the witness, then they can be on screen? Thank you. So the obligation is on the respondent to serve. Once you receive the stamped documentation, you are obligated to serve to the applicant. So it was on you to serve to the applicant that particular document when you were submitting your response. So you're confirming that you did not, so that you are confirming that you did not serve the documents on the applicant.
We are confirming that, Chairman, because we were under the impression that the document was being provided to the applicant through the OPR.
Okay. Thank you. Mr. Balrup, at this point in time, I would like to ask you if you would like to continue, or if you would like to consider reviewing those documents in your submission, in your application for review today. And you have the option for us to defer and continue this matter tomorrow.
Chairman, we have conducted a preliminary review of the document in the best interest of time and in the sense of the nature of the matter. I think we can proceed. I have no objections in the meeting.
Okay, thank you. So I would like the record to note that the applicant has opted to continue today's proceedings, and that you are sufficiently comfortable with the witness statements that was filed previous to the adjournment of the meeting earlier today. Yes? Mr. Baru?
Yes, Chairman.
Thank you very much. So as a preliminary matter, and before we continue the case for the respondent, you noted that Ms. Simone Gordon was not able to attend the proceedings to tender her witness statement and to be cross-examined. However, this matter was scheduled for both today and tomorrow. Is Ms. Gordon available tomorrow from 9 a.m.?
Chairman, we will have to confirm with Ms. Gordon because she has a family emergency, and I'm not too sure that if it will be resolved today, but we can confirm today with her. We'll make contact with her and find out what the situation is.
Well, what we will do, we will continue with the proceedings, and you can, during the duration of the remainder of the proceedings, inquire from Ms. Gordon if she will be available tomorrow, and you can indicate same to us before we are finished for today. Is that okay with you?
Yes, Chairman. We'll find out and we'll let you know. Yeah,
so we are noted. Okay, let's proceed with your first witness.
Satish Baran, our first witness.
Thank you. Mr. Baran? A little more in frame, Mr. Baran. Thank you very much. As prior to the adjournment, we would have administered the oath, so that still stands. We would now like to continue. So I'd like now, Mr. Brown, to confirm with you that you gave a statement in this matter and that the signature and date and time are the same and they are true and correct.
Yes, Chairman, I confirm date and my signature affixed to the document is indeed mine.
Okay, so for the records, this document is noted as SB1 and will be entered into the records. At this juncture, I invite the applicant to cross-examine the witness. Mr. Balrup?
Yes, Chairman. With regards to point 10 of Mr. Barron's witness statement, it is stated, throughout the procurement process for the works project, my primary responsibility was to ensure compliance with the relevant procurement regulations and guidelines governing public procurement. This included adherence to statutory requirements, internal policies, and best practices aimed at promoting transparency, fairness, and efficiency in the procurement process. Within our skeletal submission, Mr. Barron, we would have noted that in the absence of the solicitation documents mentioning the manner in which price which is outside of the engineer's estimate is treated, we contend that the process should be guided by clause 34 of the Public Procurement and Disposal of Public Property Act 2015, which specifically states that where the procuring entity is of the opinion that a submission is abnormally low, it shall request in writing from the supplier or contractor details of the submission which give rise to the concerns as to the ability of the supplier or contractor to perform the procurement contract. Prior to us being issued the notice of decision to award on the 16th of April 2024, no correspondence was received from the LSA asking any clarifications, any further particulars regarding our price, whether we substantiate our price, whether we can hold our price, what measures are being implemented to achieve that level of economy. Nothing of that sort was communicated prior to Ricky Raghunanan Limited. Therefore, we are of the view that whatever is stated in point 10 of your witness statement is not entirely correct. Is that the case?
So let me just answer the first question you posed in terms of when you sent your letter. When we issued the notice of intent on Tuesday, April the 16th, right? We were sent to get our stance here, 10 days. The following day, on Wednesday, the 17th of April, you would have sent a letter to the LSA indicating that your challenges and what your questions were. You gave us approximately less than a day to provide clarification and maybe give you an update in terms of what we would want to do. Subsequent to that, on the following day, you filed a notice to challenge the procurement proceeding with the UPR. Usually, according, to my knowledge and understanding with the UPR, the first 3 days are left for any contractors to issue clarifications, and then we would have a further 3 days to respond to any questions that you pose. That wasn't the time stipulated, wasn't given to us to be able to produce the documents and schedule meetings for you to come in. I just want Chairman to note that that initial case was then cancelled, and a new case, that is CP2024-8, was restarted. So within that process, we then at the 10-day we wrote to you, indicating that we will file responses to your claims on our Form 9 to the UPR, which I believe was communicated to you. And also, we also indicated that should you require a debriefing, although the stipulated time period would have concluded by 12 midnight on the 30th of April 2024, we are willing to facilitate your request.
Mr. Balrup, before we continue, I would like to remind you to form questions to the witness.
Understood. Understood, Chairman. Right, Mr. Baran, apologies for that. I note your response. However, in interpretation of clause 34 of the Public Procurement and Disposal of Public Property Act 2015, para 3 specifically states that the reasons, so the decision of a procuring entity to reject a submission in accordance with this section, the reasons for that decision and all communications with the contractor under this section shall be included in the record of the procurement proceedings and the decision of the procuring entity and the reasons therefore promptly communicated to us, the contractor. So my simple question is, for what reason was the contractor not allowed or not advised of the standing of his bid price prior to your issuance of the notice of decision to award contract?
So I would not have been directly a part of the evaluation team. I would refer that, I would think that you could refer that question to our QS, who has also produced a witness statement and would be open for cross-examination. She would have to be able to speak in terms of that aspect of the decision taken. But at all points, yes, Chairman.
Respondent, before we continue, I'm getting feedback on the system. I would like to advise that anyone who is not speaking at this moment, please put your microphone on mute. You may continue, respondent. Witness for the respondent.
Yes. Because I'll just repeat that I would not have directly been a part of the evaluation team. However, our QS who would have given guidance to the evaluation team has produced a witness statement and will be open for cross-examination. So that question may be better to be directed to her to clarify that issue that you raised.
Chairman, if you permit me, I would just like to direct this much to Mr. Baran. Mr. Baran, I acknowledge your response. However, it is just confirmed for me if you are stating in point 10 of the witness statement that your responsibility was to ensure compliance with the relevant procurement regulations and guidelines governing public procurement, and your solicitation documents would have assigned yourself as the person in charge of the procurement proceedings, responding to all questions from proponents, whatever is issued during the procurement stage would have been under your desk. Is it from your desk? Sorry, is that correct?
So our evaluation teams are independent. So we appoint an independent chairman who coordinates all aspects of the evaluation process. Where clarifications arises, then they consult with myself, the NPO, to clarify any issues that they have. But the evaluation process itself is done independently amongst the members of the evaluation team.
Okay, noted, Mr. Baran. Chairman, I would just like to know that we are of the opinion that the procurement manager is probably one of the most important players in such an evaluation team. However, of course, we don't know the structure of the LSA, and that is not our affairs. So we note Mr. Baran's response.
Thank you. Do you have any further questions, Mr. Baruch?
I have further questions, but I would not be able to call on Mr. Baran as he would have indicated previously. Probably when we get on to the next witness, the quantity surveyor, probably at that point it would be more appropriate.
Okay, so I take it that your cross-examination of Mr. Baran is complete?
Yes, Chairman.
Thank you. Members of the panel, do you have any questions?
Thank you, Chair. Mr. Baran, on item number 6 of your witness statement, you noted that the evaluation was completed and submitted. My question to you is, were you aware of the engineer's estimate?
Yes.
Okay. Thank you.
The evaluation report will have contained the engineer's estimate.
Thank you.
Mr. Baran, I have one question for you. In your response, a short while ago, you indicated that you would be the point of clarification between the evaluation committee, who is independent, and the bidders. At any point in time, was the issue of the value of the applicant's bid brought up with you?
No.
Thank you, Mr. Baron. We would now proceed with the other witness for the respondent.
Ms. Allen as the other witness on behalf of the LSA.
Good day, Ms. Allen. Good day, good afternoon, Ms. Allen Phillips. Would you like to proceed by oath or affirmation?
Oath is not a problem. You can proceed by oath.
You repeat after me, please. I state your name.
I, Candace Allen Phillips,
Solemnly swear
solemnly swear
that the evidence I shall give
that the evidence I shall give
to the hearing panel
to the hearing panel
in this case
in this case
shall be the truth,
will be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you, Ms. Allen.
Problem.
I'm asking you if you confirm that you gave that statement and that the signature and date of the document is true and correct. If you wish, we can bring it up on screen, or you can refer to documents you have in your possession. Can you confirm?
Yes, I can confirm that this statement was given by me and signed by myself.
Thank you, Ms. Arlene Phillips. And these documents will be initialed CP1 for purposes of the records. We may now proceed with the cross-examination by the applicant, Mr. Baru. You are invited to cross-examine the witness.
Thank you, Chairman. Okay, hi, Ms. Phillips. Good morning. So, in review of your witness statement, I note point 6 stated, while I did not prepare the engineer's estimate as LSA's quantity surveyor, I reviewed, approved, and signed off the cost for confirmation as our official benchmark estimate. So my question to you in this regard is, was the engineer's estimate at the point of the engineer's estimate rather that would have informed the decision on April 16, 2024? Were you privy to that estimate?
Yes, I was.
Okay. Going forward, we note that the estimate that was provided by yourself, or the evaluation rather, which was provided by yourself, was dated May 1st, 2024. The notice of decision to award on April 16th, 2024. What was the reason for your evaluation of the bid price submitted by Raghunanan Limited?
I was called by the evaluation committee of the CEO to provide my review, analysis, and recommendation on the tenderer's price, in contrast to the engineer's estimate.
And was that as a result of our correspondence which was sent across requesting further particulars from the LSA?
Yes, it was.
Chairman, just one quick clarification as a note to your good self. We have not had sight of the engineer's estimate, which was, well, I should say the engineer's estimate of record. What we have here within the evaluation documents and evaluation report, as well as Miss Phillips' witness statement, is her evaluation report. So my initial guidance would have been to question Miss Phillip as to, was that estimate disclosed to Ricky Raghunanan Limited? However, I'm seeking your permission to direct a question of that sort. Who do I direct that question to? Do I direct it to the panel, or am I able to include that in questioning Ms. Phillips?
Permit me to consult with my support team, and I will revert to you shortly.
Thank you.
Mr. Baruch, I'm guided that you may ask the question of the witness.
Okay, noted, Chairman. Right, so Ms. Phillip, apologies again. However, we continue. So I note that the evaluation committee, well, the three parties who would have signed off on the, let me get the correct name of this document. Just permit me 1 second, please. Right. The procurement strategy for the Romain 2 zone A, B, C, D, E works, right? Which was issued by Mr. Barron. The three evaluators on that committee would have been Ms. Simone Gordon, Mr. Kevon John, and Ms. Candice Reed. Seeing that none of these, I'm questioning as to why none of these, if the initial engineer's estimate was not included and was not provided to Ricky Raghunanan Limited, I would assume that at least some of these personnel here would be key witnesses to the matter. So the core question that I really want to ask is, who would have prepared the engineer's estimate?
The engineer's estimate would have been prepared by one of LSA's consultants for the project. However, the engineer estimate would be reviewed, recommended, and signed off by me as LSA's quantity surveyor.
And is it normal practice for the LSA to conduct that after issuing a notice of decision to award?
Conduct what exactly?
The evaluation, as you would have said by your good self, your duty would have been to conduct an evaluation of the bid price based on what was provided by the tenderer and based on what was issued by the consultant?
No, when the consultant sends the engineer's estimate before the tender process, I would review it advise that it's okay, recommend and sign it. So that process would be before the tender process.
Okay, understood. So then you are confirming that you would have been a part of the evaluation as well before the 16th of April?
No, not the evaluation process for the tender. I would review the estimates for as the engineer's estimate, review it, recommend and sign off. The evaluation process, as he stated, would have taken place with the persons that you identified previously.
No, I understand that, Ms. Phillips, but forgive me for the questioning, but it's just the procedure. The core matter, what I'm trying to ask is it LSA's practice for the external consultant to make a decision on what is meaning, okay, is the external consultant the sole recommendation for your decision to award a contract?
The external consultants in this instance were not part and is usually not part of the LSA's evaluation team, so they don't make recommendations for any tender. It is done internally with LSA's evaluation team.
Because the manner in which the way it has come across now is that you have provided a report on May 1st. However, what took place beforehand to inform the LSA's submittal of the notice of decision to award contract on the 16th of April would have been solely relying on the engineer's estimate provided by the consultant, right?
No, it would not have been solely dependent on the engineer's estimates. There is the there's the evaluation criteria, which would be the technical and the financial. So it's not totally reliant on the engineer's estimate.
So is it that it would have been required of you to sign off on the engineer's estimate prior to the 16th of April? Were you involved in signing off or endorsing in any way or making recommendations on the engineer's estimate prior to the 16th of April?
Yes.
And could a record of that be provided? Because, forgive me, again, we are proceeding in the matter, and if it wasn't included and I have inadvertently not have sight of it, just please direct me to if that is indeed included within the evaluation report.
I do not believe it would have been included in the evaluation report, the full engineer's estimate. They would have used the estimate, yes, but I do not believe it would have been included for your matter, but it would have been included in the evaluation committee's report. And I was not part of the evaluation committee, so I will not be able to state 100%. We would need to confirm with the committee because I was not privy at that time to the evaluation report.
Okay, but just by chance, you have the date that you would have signed off or made your comments to the evaluation committee prior to the 7th of March?
No, I don't have that in my possession here, but I can get that requirement.
Okay, noted.
Mr. Balu,
Right. Yes, Chairman.
I just inquiring whether you wish to continue or if you're finished. Are you continuing?
Yes, Chairman, I'm continuing.
Proceed.
Right, Ms. Philip. So from the evaluation report, we would have noted a summary of the engineer's estimate, and we would have noted each of the individual 1, 2, 3, 4, 5, 6 proponents, right? Maraj Hill Limited, Calco Limited, Petrotrin, Satsys Limited, SAS Marketing, and ourselves, Raghunanan Limited. Within this, we would have noted that the overall variation is -2% for Maraj Hill, minus 18.95% for Calco, minus 16% for Petrotrin Limited, minus 24% for Satsys Limited, 51% for SAS Marketing, and minus 26% for Raghunanan Limited. Notwithstanding the fact that at no point the engineer's estimate was provided to us during the clarification stage, if I may, we note that the So the roadworks, according to the engineer's estimate, is $5,596,000, right? That is according to LSA's engineer's estimate, giving a subtotal for the project of $14,939,046.98. So that would have been the LSA's engineer's estimate for the job. So the question I'm posing to you now is, I note that Calco's submission for the roadworks in particular is 60% lower than your proposed, well, I'm saying your, but the LSA's proposed engineer's estimate, right? Whereas Ricky Raghunanan Limited in that aspect is a negative 41%, well, of course, be below the engineer's estimate. So my core question in that regard is, what consideration is given to a contractor who is 60% below the engineer's estimate in an item which is almost 1/3 of the contract value? How do you treat with that?
So we would look at each item, yes. However, we also would look at the overall contract amount. Additionally, we would look at who would be the provider. For instance, in your technical document, you would have identified that you would be supplied your bitumen from Danny's Enterprise. We would look at who would be the supplier of the other person, whether they have their own plant, what would be the purpose or what would be the result of their price being lower. In addition to that, we look at the overall cost. So where a tenderer might fall short in one area, they might be able to make up in another area. So overall, their cost would have been higher than, well, more than yours. So even if you're saying that they were lower, they would have their reasons. However, they would be able to, within the range or within the cost, they would be able to complete the full project, whether there's a negative in one area and a positive in one area.
Noted. However, do you believe that it is necessary for the LSA or the procuring entity for that matter to request clarifications rather than making assumptions in some cases?
In some cases, yes, but again, once we could look at the overall and ensure that it can be done for that price, it's within the contractor's remit how they do it, as long as we are sure that the risks that are being mitigated would be catered for.
Noted. However, again, would you have the information as to why Ricky Raghunanan Limited was not required to provide any clarification on its bid price prior to issuing the notice of decision to award?
No, I would not have, as I was not part of the evaluation team, I would not have that information.
Chairman, just permit me one question. So in a case like this, who do we direct the question to? Is it that we direct it to the panel and the LSA will designate a respondent?
No, not in this case.
Because there are a couple, I mean, you're the matter, and my core question at this point is, in a similar manner to previous matters where the LSA would have sent a letter requesting clarification prior to issuing a notice of decision to award in accordance with clause 34 of the Public Procurement Act. Why was it not done in this case? And we just came, and just after we submitted our tender, the next thing we saw was a notice of decision to award. No clarification was asked for any item, and then we are served with a notice of decision to award.
Just a reminder, Mr. Barrow, before I'm going to take a short pause to confer with my support team, but just as a reminder, references to previous matters, if they were not included in any of the documentation that you have submitted or that the respondent has submitted, we are limited to referring to the facts before us at this point in time. So kindly refrain from referring to previous matters unless they were vented previously. I'm going to take a short pause. I will take a short pause and I would resume. Thank you. Thank you, applicant and respondent, for the brief timeout. Mr. Balrup, I note your concern and some of the concerns you have. You may raise it in your closing submissions.
Okay, Chairman, noted.
Are you proceeding with further questions, sir?
Yes, I'll proceed with further questions, but I just want to have one clarification. As you mentioned, the closing statements. So for example, I would have made reference to a previous case. Could that be substantiated and included within the closing statement, or we are only guided by
You
what
are
is
you are
required?
guided by information that would have been presented in your Form 8, the application, as well as other documentation that would have been provided to the board and to the respondent at that particular time in reference to the matters before us. So if you didn't do that before, it cannot be accommodated now.
Understood, Chairman.
You may
So I'll
proceed.
continue. I'll continue. Right, Ms. Phillips. So again, directing the question to the LSA. So was Calco Limited invited to provide any clarification regarding their bid price?
I will not be able to speak to any process that would have taken place during the evaluation stage, because again, I was not part of that process. So I'm not aware of any clarifications, any questions to any of the other tenders.
Chairman, how do we move forward in this regard? Because it's unfortunate that the few questions that I have now, it really cannot be directed to Ms. Phillips based on what she just said. So how do we seek clarification in this regard? Who do we ask?
Sure. Permit me a short pause again. Mr. Balrup, to assist me with your question, I would now be asking the respondent a couple of questions.
Okay, Chairman.
Respondent, I would like to inquire, and this is not directed to you, Ms. Phillips, but to your the representative of LSA, the respondent. Have you? I would wait shortly for him to be on screen.
Chairman, I'm here.
Yes, thank you. At this point, I would like to confirm whether you have contacted Ms. Gordon and in terms of her presenting her witness documentation.
Chairman, we have contacted Ms. Gordon and she will be available tomorrow.
Okay. Thank you very much, respondent. Mr. Balrup, Ms. Gordon, who is one of the witnesses listed in our proceedings today, may be able to answer some of your questions based on her role in the proceedings. Do you wish to continue? We would be convening tomorrow, seeing that we have confirmed that the witness is available.
Yes. Well, then we'll continue with what we can, and of course, yes, we will go on to tomorrow's proceedings accordingly.
Thank you very much, respondent. Do you wish to further cross-examine the witness, Ms. Phillips?
No, Chairman.
Thank you very much. Thank you, Ms. Phillips, for representing today.
No problem.
Right. Panel, do you have any questions? Oh. Hold on a second. Mr. Respondent, I would like to bring, we still have some questions for Ms. Phillips. You can bring her back into view, please.
Okay, Chairman.
Panel?
Ms. Phillips,
Yes.
point 8 in your statement, you indicated that based on your professional judgment and industry experience, it is your view that the applicant tendered price, it does not reflect a realistic and feasible approach
to completing the works within the specified parameters with minimal risk to the LSA. Right? This is your view from a professional standpoint, right?
Yes, it is.
Did you document your view, and did you prepare a risk assessment, right, and a risk management plan vis-a-vis, right, in support of your view, right, to identify exactly where the significant risk, right, as you spoke about, right, exactly where those risks occurred or existed?
Yes, I did, and it would be in the evidence in the witness statement, CAP2, which was the memo dated May 1st to the CEO of LSA, identifying a breakdown of all items of work and where exactly the risk would be within the tenderer's price. There was a detailed comparison and breakdown referencing all the items where I found would be too low and which would be a substantial risk that we have to look at mitigating.
Yeah, that's supplemental. Yeah, I got that. So that's the one with the tables. Yeah. Yes.
Hold on.
On cap 2, table 2, right, under BOQ reference 404.4, 407.4, right, you indicated what the bid prices were and what the recommendations were. And there was some difference between both prices. Did you seek to understand the reason for the differences in those prices, or did you form an opinion just based on the numbers that you saw before you without engaging the applicant?
I did not engage the applicant. However, there would have been sufficient, in my opinion, information within his standard to look at the price. For example, I would not have called him to ask what was the price they would get the asphalt at. However, in his standard document under the day works, he would have listed the price he'd be getting asphalt at. He would have listed the price of his equipment. So I use the tenderer's information from the tender to look at his rates and look at his price to see if it's in comparison on how it would translate with industry prices.
And were those rates and prices consistent with market rates and prices as opposed to the other tenderers' rates and prices?
I did not look at the other tenderers' prices. I was asked to review the tenderers, or the applicant's prices. I did not review anyone else's price.
Were they consistent with the market rates for those two particular items?
There were discrepancies within the price that they said they were getting it at and the price and their rate. So, for example, as stated in my memo, the tenderer noted that he would get the asphalt at a price of 3,900 per cubic meter. I used industry price, or I used a price from another supplier, which was even cheaper than his cost, and yet the rate still was higher. So there was discrepancies between what he said he was getting it at and what the actual rates were.
That is when you did your market research and comparison.
Yes, so that also highlighted a risk that the prices would be under if you're getting something at a particular price, as you stated. However, it's not reflected in your rates. It poses a question of how did you come up with the rates if it just was not aligning.
And we did not seek to try to understand from the, well, you said you didn't engage, but
No.
you may not be able to answer that question, right? In terms
No,
of
I would not.
understanding from the applicant, where did you get these numbers from?
Pardon, could you repeat?
I said you didn't seek to understand or to inquire from the applicant. Where did you get these numbers from?
No, that was not my that was not what I was requested to do at that time. The request was for me to review the applicant's tender prices and look at it in terms of whether it's feasible and what would be the risk of award or awarding to that tender.
And did you probably thought, right? Did it cross your mind that in doing your review and informing your opinion, right, of the information that was presented before you, right, that there is a need for further clarification to be sought by your organization, right? And as such, included that in your report or directed it to your superior, right? So that the appropriate action could be taken.
Yes, I did in the report. Whether I stated an opinion, I also stated that this is my opinion and the justification would have to be made from the applicant.
Are you aware if the applicant was engaged by the organization?
This was done after, within the process, so I do not believe that at that point we could have called him in to justify at that point, because we were already in the process with the OPR and with the applicant's claim.
I turn to the last table on in your notes. It doesn't have a number. So you have a table 4, and after table 4, then there's another table with no number. Right. It contains 7 items from preliminaries to day work.
Yes.
I observed the bid price in one column. So item, description, bid price, recommended price, and variance.
For clarification, the recommended price is my price, yes, and the bid price is the applicant's price. So we don't have the engineer's estimate here. It's just their price and this is a personal recommended price if we go in at the lowest that we're saying that he could go.
What I found in reviewing this, right, item 2, 3, 6, and 7, right, there was no real variance no variance at all, 0 to the last cent, right, on the numbers quoted. Could you it's interesting that the recommended price can be so exact, right, when compared to the bid price. Right. Is there an explanation for that?
Yes, to clarify, the recommended price where you're saying a variance is 0 is where I would allow and say, well, okay, he can't do it for that price. If he says, when I looked at it, it's okay to do it for that price. So again, it's not the engineer's estimate price. This is the recommended price whereby I would have reviewed and said, well, okay, this is his price. He can do it for this price. Where you would see the variance is where I looked at and noted that it would be impossible to do it at that price, especially those 3 items.
And when we compare the recommended price, right, with the engineer's estimate being what, around $18 million? 18?
18.4.
Yes, around 18.4. And we look at the recommended price of $12.5 million, right? There is really a significant difference between one and the other, right? How do we explain that?
Right. So in looking at the recommended price, we would look at, I believe I stated it in the memo also, the tenderer being able to provide whatever equipment, the minimal price for his equipment. Say he doesn't charge for his equipment, he only charges for an operator or consumables. So the recommended price would look at the absolute bare cost, minimal profit of where he can go. So that is why you would see a difference between this recommended price. So this recommended price would be for this tenderer for the project.
In considering sorry.
No, proceed.
In considering item 4, the road works, right? The recommended price and the bid price and the engineer's estimate. How do we account for, right, or provide an opinion on the reason for the variance across those 3 specific items or areas, the bid price, the recommended price, and the engineer's estimate?
So I would have to confirm with the engineer's estimate price, the roadworks price. Right.
5.5.
The engineer's estimate roadwork price was $5,596,000 in comparison to this recommended price again, which would look at a minimal cost of $4,566,500. So what I would have done when looking at his price and recommending was stating that, okay, we would look at him having the equipment, we would look at a minimal cost. What is the minimum cost he could provide? And material is hardly subjected to any major difference. Your material price is your material price. The only areas that he could look at, or we could look at that he may save, would be within his labor costs, his equipment costs, etc. And especially with the fact that he gave in his deals a price for the asphalt, I was able to say, well, that can't work. So the only other areas he could have looked at, or we could have looked at where he could propose a reduction, would have been his equipment, his labor costs, etc., consumables.
You focused on the cost of asphalt and the asphalt cost, that the bitumen cost that the applicant would have proposed. And you said that, in your opinion, there was a difference, right, between when you did your market check. How significant was that difference in terms of numbers, right, as opposed to what was proposed as compared with what is recommended, as compared with the engineer's estimate?
Okay, to show the discrepancy, as noted in my memo, his price his price that he said he was getting the asphalt at was actually higher than the price that I used when I did my recommended from industry, basically industry prices. So it was actually higher. So I expected with that cost his asphalt rate to be higher, but it was not. So that showed a discrepancy between what he said he's getting the price for asphalt at and the price that he's able to complete the works with. So his price was actually high. The price he was getting the asphalt at was actually higher.
And is it that you then saying that when you convert that price, that number, right, and roll it up in his total cost for road works, right? If you made an adjustment, right, as you indicate that it was higher, then his roadworks price, right, ought to have been higher.
Well, I could say yes. However, he could say that his equipment cost would have been non-existent because he has equipment and he would only put a particular the operator's price, etc. However, that is a minimal part of the full rate. The bulk of the rate is the asphalt price, which we didn't use an arbitrary figure. He stated his price within his deal, so I was able to use his price there without contacting or asking for clarification. I used what was actually tendered.
Thank you, Mr. Phillips. No further questions at this time.
Ravi, do you have any question?
Thank you, Chair. Ms. Phillips, you mentioned during your cross-examination from Mr. Balrup, by Mr. Balrup, that you received the engineer's estimate prior to the award of the contract.
Yes, I did.
Great. What work did you do to compare the engineer's estimate to market values?
So I would have called, we have lists of material prices, just look at material prices, labor prices, and ensure that it was in line with industry prices, or industry rates.
Thank you.
Mr. Lichi?
Mr. Phillips, having reviewed the engineer's estimate, right, at that point in time, right, and then in your report, right, and that last table we just discussed, right, yeah, and looking at your recommended values, right, noting that there is a significant difference between those recommended values and the engineer's estimate. No. Why was it? Were we able, when we were doing the first review of the engineer's estimate, to be able to identify and say, I think that this engineer's estimate is off, right? Because we're talking 18 million to 12 million, right? And depending on how you're looking at it, right, 18 million can become 50% more of 12 million. Or if I look at 18 to 12, I can look at 12 million as being 33 and a third percent less than 18 million, right? So at that point in time, when you were reviewing the engineer's estimate, did that anomaly, right, or abnormal sort of pricing, right, pop up for you to consider in your professional view?
No, it did not at that point. Because when doing this recommended price, I would have gone at bare minimum to be fair and to see if it really could be done or how abnormally low this price was. The engineer's estimate would be standard. However, this recommended price would look at a bare minimum per se of the contractor being able to do the work. So this recommended price is in relation to the contractor being able to do the work at the minimum price which would pose a higher risk. And also there's a range. So our range is quite wide, right? The 19% lower. So it would take into consideration all that within the whole process. So at that point, there wasn't an anomaly or anything with the engineer's estimate. The engineer's estimate at that time was okay, taking into consideration all risks, the risk of price of asphalt going up, going down. It would have taken into consideration all that at that time. So there wasn't any factor to change at that time. This recommended price looks at a minimum with a very high risk in doing the work and in providing these routes.
If we look at the recommended numbers, right? And we're saying that that is bare minimum. And we agree that to make some adjustments here. The bare minimum would include some element of contractor's profit inside of there, right? And if we adjust this bare minimum, right, an additional 20%, right, which would be reasonable within the industry, right, particularly given the market in Trinidad, in the country for this particular service. 20% will take us up another 2.4 million, right, which is going to be like 14 million, right? I'm trying to understand the rationale, right, behind the whole issue of accepting the engineer's information at one point in time, right, and then presenting a recommended price list at another point in time, stating that the recommended prices is at bare minimum with low profit margins. And if we take this and we say this is cost, then we add 20% onto it, right? Another 2.4 million, right? And considering the market conditions, right, in the country, as far as road work is concerned, road paving works are concerned, right? We're going to come up to a delta of still about $4.4 million or thereabouts on the engineer's estimate. Yeah. For me, I'm trying to understand how is it we could rely on the engineer's estimate, right, under such circumstance.
So there must be a benchmark, and the benchmark would be at a middle ground, which is why we have the ranges. So one contractor would be able to provide all the equipment because they have all the equipment, so they may basically be lower than another contractor who may have to rent a particular equipment. The engineer's estimate would be a benchmark of the prices, and this recommended price, I looked at Ricky's technical, so I would have looked at what he says he has and put it at a minimum at no cost to this process. So this recommended price here is even at great risk, but it was in the interest of being fair to him. So the engineer's estimate is what we stand by as the benchmark, but we are looking at the lowest that he could possibly go to be able to get this contract out. So that is where the difference is with the engineer's estimate and this recommended price, which is very much in line for the contractor. So this recommended price may be different for another tenderer if I have to review, because I would look at what he would have stated in his technical documents, what resources he have, what is his methodology, and how we would be able to do it. For example, if I may, under his preliminaries, in that same document, I would have highlighted, and this should speak to, the other items. So I would have highlighted under his preliminaries 3 separate items in table 1. The insurance, the project sign, the construction finishing equipment. And I would have stated that, okay, for example, the project sign, his bid price was $3,500. So I would now take into consideration, maybe the tenderer have all the materials on site. They don't need to buy anything. However, labor and equipment must be provided because you have to now install it. So let's say, for example, you have all the equipment. So now we look all the materials, now we would look at the labor aspect of it. So for another tenderer who may not have that, I would say, well, he has to provide materials. So their price, their recommended price may be more. So it would be in contrast or using his technical documents and his resources as identified in the standard to come up with the prices. For example, 100.5 in that same table 1, his bid price was 80,000. I would have looked at what he said he's providing. So in his technical documents and his methodology, he said that he's providing a water truck daily. He's providing a list of persons on his org chart. How does that translate now with what the tenderer said he's doing with the price? So the price must be in line with what he said he's providing, or how much, for example, the day works cost that he said he's providing. So if he's providing a list of 5 persons and I look at his prelims, and for that item, it's low and it cannot cover, I would say there's a risk that something is wrong there. Because how could you say that you have 10 persons working on this project and then you have a cost of 10,000? So I would look at there is a discrepancy in that area. So that is how I would relate to that document and his prices.
Thank you.
Ms. Allen? Question.
Yes.
Between the period February the 1st and April the 16th, 2024, did the evaluation committee request from you any bid evaluations?
No, they did not.
Thank you. Thank you, Ms. Allen, for your submissions and for representing the respondent. At this point in time, the respondent has indicated that the witness, Ms. Gordon, will be available tomorrow. So at this point in time, we would like to stand down today's proceedings and we would reconvene tomorrow, where we would continue with the witness tender and the witness statement of Ms. Gordon. And thereafter, we would close the proceeding. But before we close, let me just confer with my support team for some housekeeping information. So, So just to clarify some clarification on use of language here. So we would be adjourning until tomorrow. Mr. Balrup, I see your hand up. Do you wish to redirect any questions? Would you wish to submit any more questions to the witness?
Yes, Chairman, that was my intention. I wanted to inquire if the proceedings permit that I could still continue questioning.
You may.
Okay, noted. Miss Phillips, I note you make reference to the day works continually, right? And it seems to me that your understanding of the day works are a price list, basically, what a contractor would get a certain item for, what we would pay to purchase asphalt, what we would pay to purchase, whatever it is. But my question to you simply is, did it ever occur to you that you should have reached out to the contractors during preparation of any evaluation?
I was not on the evaluation team, so I would not be able to speak to that. I was asked to provide a review and recommendation of my rates in relation to the cost. So that was what was done here. And also, the prices that I used was not your day worksheet. I would reference your day work, but I would use industry prices. So where I would have said for the asphalt, in my document stated that I used a price of 3,133 per cubic meter. However, you said 3,900 per cubic meter. I used my price to come up with the rate, as we could see in the table, right? So at that time, I would not have been able, and I was not requested to get clarification from you. This would have been an independent assessment for the team to look at. Any clarification for the tender process would have had to be done by the committee for the tenders evaluation. I did not evaluate within the tender documents. I did not evaluate at that time.
Okay, so I just have 3 last questions for you, and if you can respond to them, you will let me know. If not, we will redirect them to probably Ms. Simone Gordon tomorrow, right? But the first one is, you did indicate that you provided, I don't want to quote wrongly, but you signed a document. You would have signed a recommendation or whatever you call it and presented it to the evaluation committee.
Yes.
Right. That was pre-issuance of the notice of decision to award, right? That was at that point in time. Right.
Yes.
I previously asked what date that was done, and you indicated to me it was not before you. Could a date be?
It was done before this process, but I cannot remember the exact date. I said I would be able to check it and get back to you with the exact date. At this point, I don't have the document in front of me to confirm the date, but it was done before the whole evaluation and tender process.
Okay, so regarding that, what I will be requesting is, of course, you'll clarify exactly what date it was. Secondly, was that a hard copy document, or did you email it to the committee, or who was it attentioned to?
The document would have been a hard copy document. Attention to the procurement department, sealed in an envelope and passed for the tender.
Okay, and the method by which you would have received the engineer's estimate, what was that? Was that emailed to you, or was that in a unopened envelope, or how was the engineer's estimate presented to you?
The consultants would have hand delivered in a sealed document the engineer's estimate.
Right, and at what, could you confirm what date that was delivered?
I would have to check back. I can't confirm the date right now.
And could you disclose the name of the party who would have prepared the engineer's estimate?
The consultants, I would have to confirm also on that. I would not be in a position to give you that information until I confirm with the team and also confirm that information.
Okay, well, Chairman, if that's the case, I guess if we don't get the responses, probably we could present these questions again tomorrow. Is that how it would go, or those matters would have to be addressed before the final closing comments and stuff?
So, thank you, Mr. Balrup. You may continue. Have you finished with your questions?
No. The question I would have indicated before we stop was,
right. Yes.
Would we present these questions again tomorrow if we don't get a response, and it must be addressed before we close the proceedings tomorrow?
So, Mr. Balrup, so in terms of your questions, the respondents may present the information in their closing statements. However, it's up to the panel to consider the information being given and consider it as part of our deliberations. In terms of asking these questions, if it refers to information in the witness statement that you can get from the witness statement, you can ask those questions based on the witness.
Understood, Chairman.
So, are you finished with your questioning?
Yes, that's it for Ms. Phillips.
Thank you once again, Ms. Phillips. Okay, so once again, we're noting that we are adjourning until tomorrow, where we would continue with the tendering of the witness statements. The respondent would have indicated that Ms. Gordon will be available tomorrow. Therefore, we would continue the proceedings tomorrow, beginning at 9 a.m. We'll begin at 9 a.m. tomorrow. So we would reconvene at 9 a.m. tomorrow to continue today's proceedings. Thank you very much to the applicant and to the respondent. Mr. Baru, question?
Yes, we utilize the same link, right? And I'm just confirming that yet. 9 o'clock
Yeah, so
in the morning. It was a previous.
with the IT.
Right?
Yeah.
Right.
Let me quickly confirm with the IT team. Yes, we would be using the same link.
Great, Chairman.
And of course, you have the various numbers that we would have provided in the housekeeping rules. Should you have any issues, try and vent them quickly before that time so that in terms of access, so that we can accommodate you. In terms of housekeeping, after the witness statements, I remind the respondent that you must serve the reply today before 4 p.m. and the applicant can note any issues in relation to the attached supporting documents in your closing submissions for consideration by the hearing panel. So respondent, you're reminded that you have until 4 p.m. this evening to submit the documents that you need to provide this afternoon. Clear?
Okay, Chairman. Chairman, can we reiterate what documents that would be?
The reply, which would have included the summary and the evaluation document that the applicant would have mentioned earlier. The reply document.
Is that the evaluation report which was submitted through the OPR, Chairman?
Yes.
Okay. Okay, Chairman.
Okay, thank you very much, sir. So we are hereby adjourned until 9 a.m. tomorrow, the 17th of May, 2024. Thank you very much, applicant and participant, and all other supporting team members here today.
Thank you.